Hello, America and the world. This is Radio Free Market, and I'm your guest host, Zoe Russell, standing in for Radio Free Market founder, Michael McKay. We are behind the lines of socialism, and Radio Free Market is the voice of free people and free markets. Our topic today is Nullify Now, why we the people cannot trust the federal government to police itself. I am thrilled to welcome our guest today, Michael Boldin. Michael is the founder and executive director of the 10th Amendment Center, the nerve center for people across the country working to hold the federal government at bay by declaring unconstitutional edicts null and void in their state. Michael, thank you. Welcome, and thank you so much for being with us today.
Zoe, awesome to be here. Thanks for chatting.
Well, back in September, Michael McKay, the founder and host of Radio Free Market, did an excellent show on nullification with Dr. Tom Woods, the author of Nullification and a mainstay speaker along your Nullify Now cross-country tour. They covered some of the history behind what the founding fathers believed about the power of nullification. So I'd point everyone listening today to our archives on radiofreemarket.com to find this show and listen if you haven't heard it. For those of you who haven't heard it, we'll quickly go into the background of nullification on this show. So, Michael, what does nullification mean, and how did it come about in the United States?
First of all, if you want to get the historical understanding of this, there is no one better than Tom Woods on this. You can visit his website, too, at tomwoods.com, and he's got tons of great resources on this issue, of course, plus his book, Nullification, How to Resist Federal Tyranny in the 21st Century. The idea behind nullification, it's Jefferson's answer to the essential question, and I think this is the essential question not only of the founders' time, but of all times. When the government that works for us violates the rules that have been given to it, what do you do about it? And for us, there's a lot of answers, or possible answers. Do we go to Washington, D.C., and do we march on D.C., and do we demand that the federal government limit its own powers? Do we go to federal courts and ask federal judges to limit federal power? Do we vote federal bums out and hope that the new guys aren't bums and they'll just limit their own power? Well, Thomas Jefferson and James Madison both warned us that if there was ever a situation where the federal government ever became the sole and exclusive arbiter of the extent of its own powers, they decide what their own powers are, that those powers would always grow, whether we had protests or lawsuits or elections or whatever. And they said that the real solution is when the federal government does violate its limits, is we're supposed to look to our state governments to stand up and say no, to refuse to comply, to resist those unconstitutional acts.
Right, so we have to understand the federal government basically as its own team.
Sure. I mean, if you think of it this way, if I was in the middle of a divorce, for example, and we had to go to arbitration, I may say, my mother's a really fair woman. She'll be the arbitrator. She might rule in your favor, but, you never know. She'll probably end up on my side. Well, that's probably the truth. And that's how we look, for example, at the Supreme Court. It's part of the federal government. So to assume that it's an impartial judge between the federal government and the states is absurd, and I think history has shown us that when it gets down to the Supreme Court, more often than not, they have expanded federal power rather than ruling in favor of the founders' view of the Constitution. And that's where the states are supposed to step in. And there are examples where the states have, in essence, ignored what the federal Supreme Court has said and just done what they were supposed to do anyways.
I see. So I think it's important to take a step back and note exactly how the Supreme Court justices are put on the bench. The Senate fixes the number of serving justices, the President nominates the justices, and the Senate approves of those nominations. It doesn't really get more federal than that.
Sure. I mean, really what they are, they're unelected, unaccountable, politically connected lawyers. I mean, if you were going to have a survey of people of who's the type of career person that you're going to be least likely to trust, lawyers don't fare too well. And if we're thinking of what the Supreme Court is made of, that's really what they are. They're politically connected attorneys, and we have to keep that in mind, that they're going to be.
Let me interrupt you here. Sorry about that, Michael. We're going to take a break here and come right back to this point. Welcome back to Radio Free Market. I'm your guest host, Zoe Russell, here with Michael Boldin, the founder of the 10th Amendment Center. We were just talking about the Supreme Court justices. I'd like to talk about just even the most recent example, Elena Kagan. What is her background exactly?
Well, she was an attorney for the federal government, so you've got someone who has made their career out of arguing for expansive powers of the federal government. If you really look at the Constitution the way you're supposed to, which says that we, the people of the several states, we created the federal government for certain enumerated or listed purposes and nothing more, then we would understand that most of what the federal government does is not authorized. So anyone arguing in favor of the federal government has made a complete career and a habit out of arguing for constitutional violations. So this is the type of person who also says that, if the federal government decided to tell us what to eat for the day, that it wouldn't necessarily be unconstitutional. So this is a person that argues for virtually unlimited power and is now part of the so-called impartial court. Right,
and she might have not very long of a time period before she does have that very case standing in front of her with this new Food Safety Modernization Act coming to pass. Can you just tell us about some of the rubber stamp cases that make it clear to you not necessarily to trust the lawyers in black robes to uphold the Constitution?
Well, I think there are many, and you can go all the way back to the Dred Scott decision years and years ago when they basically ruled that a black person wasn't a person. I don't know how anyone could trust any court with that type. 2005, there was a case called Gonzalez versus Raich, where a lady in Northern California, my home state, was growing marijuana under the California medical marijuana law. Not selling it, not buying it, just growing it and consuming it in her own home. And the federal government ruled that that was somehow interstate commerce, and they could control it. And Justice Thomas actually said something really important about that case, and he said basically, and I'm just paraphrasing, that if the federal government can control the growth of a half dozen cannabis plants for personal consumption on someone's own home, then Congress has virtually no limits. And whether they look to control drugs or guns or anything else, they'll do so under this precedent. And I think he's been right. We've turned a blind eye year in and year out to small precedents and some large ones that the court has ruled on, and they continue to build off of it. If you ask someone like Nancy Pelosi, where do you get the power to force people to buy a health care plan? If she even dignifies us, her subjects, with an answer, she'll laugh it off and say, well, the Commerce Clause. And this is what Justice Thomas was talking about there. They don't have the power to do this. They just take it. The question is, are we going to continue to allow it or not?
Right. Well, we've seen from various cycles and partisanship over the years that we can't, like you said, vote the bums out and depend on a fresh batch of federal governors to come in and repeal legislation. I'm sure that you don't expect this new batch of Republicans to live up necessarily to their campaign statements. You're not willing to shut down the 10th Amendment Center anytime soon?
No. Well, we started the 10th Amendment Center back in mid-2006, and if you recall, there was a gentleman named George Bush in office then, and they were passing things like the Real ID Act or the No Child Left Behind or the Patriot Act, and then they went on with bailouts. I mean, there was endless violations, and we realized that it doesn't matter year in and year out for probably a century. It doesn't matter what political party is in power or what person occupies the White House as president. Political power in Washington, D.C. always grows endlessly,
right,
and our liberty is always less. So I think to continue to look to the federal government and hope that we're going to have someone ride in on a white horse to fix everything is a failed strategy.
Right, and even as you said, President Bush, I'm sure that Obama is looking back at the precedents that Bush set I saw an article on the 10th Amendment Center blog, which, by the way, is great. And it said Obama is looking at past precedents to see how he can sort of sidestep the Constitution. So, I mean, how can states protect themselves against the executive branch and bureaucrats and executive orders?
Well, the answer to your question, well, first of all, I would say that, and like my good friend Phil Russo, he's host of Tea Party Patriots live radio show, he always refers to it as the floor and the ceiling. He says that an administration never looks at the previous administration as the limit of what it can do. It looks at it as the floor. So George Bush expanded Clinton's power, Clinton expanded the other Bush's power, and Obama is going way beyond what Bush is. And we can only expect that the next president is going to continue that pattern because it always happens that way. But what can states do? They can do what many of them have been doing already. If we look at the Real ID Act as an example that went through in the Bush administration, starting in 2007, over 24 states passed resolutions and binding laws refusing to comply with the federal act. Well, what's happened? That law is still on the book. It's never been repealed. It's never been challenged. Why? Because when enough states and enough people refuse to comply with Washington, D.C., there's not much that the federal government can do to jam their unconstitutional laws down our throat.
Mm-hmm. I've heard you say it's mass civil disobedience. So have they gone back to the drawing board with the Real ID Act? Do they have another bill coming down the pipeline that you know of?
They probably do. They had another one called the Pass ID Act, but there's been so much resistance to the original version, you don't hear a lot of noise about it coming from Washington, D.C. The only noise you'll hear is an occasional person will bring up, well, maybe we need to finally defund this Real ID Act, although they were trying to force it on all the states. We have a model for success, so if they come at us with another version of it, we realize that we can actually stop that one dead in its tracks as well. And yes, it could be considered mass civil disobedience, but in essence, maybe I'm wrong on that. I think about it quite often. Is resisting an unconstitutional law disobedience, or is it really obedience to the Constitution? Because who's the one that's being disobedient? It's the federal government. And it's because they never follow the rules that we, the people of the several states, have given to it.
Mm-hmm. Let's travel back in time. I just want to make sure that we make the point. There's some people that might automatically shun the idea of nullification as having to do with secession or slavery, but the history defeats this association. Can you tell us a little bit on our Used Against Alien Sedition Act?
Sure. Well, actually, my point would probably be a little bit later than 1809. It would be throughout the 1850s, for example. And there was a federal law on the books called the Fugitive Slave Act. And this is one of the most horrific laws ever passed in the United States. It basically said if anyone escaped on the railroad, any slave escaped and got to the north, and somebody claimed that that black person was their property, then the state in the north was required to send that person into slavery, no questions asked. Well, a number of northern states, courageous ones like Massachusetts, Wisconsin, and others, said, we're not going to go along with this. And there's a great story of a man named Joshua Glover. We're going to be focusing on this particular instance at Nullify Now in Cincinnati in March. He escaped on the Underground Railroad, got to Wisconsin, and the people of Wisconsin rallied to his defense. They broke him out of jail. The Wisconsin Supreme Court upheld their action. They said the Fugitive Slave Act was not binding on the state of Wisconsin, and they would never send a person into slavery without at least giving them a trial or habeas corpus, their basic rights. And this is a heroic act, and it was not uncommon for northern states to use the principles of nullification brought to us by Thomas Jefferson to resist an unjust and evil federal law, the Fugitive Slave Act.
Right. Yeah, I know that Tom Woods brings up the three clauses that are normally used to distort the Constitution: the Commerce Clause, the General Welfare Clause, and the Necessary and Proper Clause. But I'm still confused on the Supremacy Clause. Can the federal government really cite this to mean supremacy over everything local?
Well, that's what they do. I mean, anytime the federal government claims something, well, it's more the pundits and the politicians who you'll often hear saying that, oh, well, we can do whatever we want. In fact, there was a bill proposed in the Tennessee State House last legislative session called the Healthcare Freedom Act. And in essence, this law was saying that, well, the federal government is not a care plan on someone, so they are going to pass a law that said the Obamacare mandates were illegal in the state of Tennessee. Well, the Tennessee Attorney General said, well, goodness gracious, there's this supremacy clause, and the federal government is supreme in all situations. Of course, what he's doing is he's counting on the fact that the average American has not read the Constitution, because it's very straightforward. The supremacy clause says that all laws passed by the federal government in pursuance of their enumerated powers are supreme. So, for example, the federal government is authorized to build a post office. It's in Article 1, Section 8 of the Constitution. So if the federal government is building their post offices like they do, or running their post offices, and a state decides to create their own, well, that's in conflict of an enumerated power. And so, therefore, federal law is supreme in every situation on that. But on anything that has not been delegated to the federal government, and that's most anything, then the state laws are technically supreme. And if we listen to what James Madison said in explaining the Constitution in the Federalist Papers, he said the powers delegated to the federal government are few and defined, and reserved to the states are numerous and indefinite.
Right. So we can look to the 10th Amendment Center to adhere to the Constitution on every issue, every time, no exceptions, no excuses. I really like that y'all put a line in the sand over and above partisanship. So this might have to wait till we come back, but what would you say to people who hold the belief of a living, breathing Constitution?
Well, I hold the same belief that Professor Kevin Gutzman, author of Politically Incorrect Guide to the Constitution, has said, that if you believe you have a living, breathing Constitution, you actually have a dead one, because rules that change on the whim of leaders are no rules at all.
I see. Well, folks, let's take a break here, and when we come back, we'll start up this conversation again and see what kind of nullification initiatives are going on around the country. And we're back with Radio Free Market. I'm your guest host, Zoe Russell, here with Michael Boldin of the 10th Amendment Center, who is defending our liberties through nullification. Let's just go through some of the initiatives going on around the country. I know you told us about Angel Rake's case against the Supreme Court, with the federal courts predictably acting as a rubber stamp in favor of the federal jurisdiction using the Commerce Clause. So what is happening now in California and other states with medicinal marijuana?
I think marijuana is one of the shining examples of how nullification works. And it's also a shining example of what you had alluded to before the break, which is that this isn't about political parties. The Constitution isn't about Republicans or Democrats. It's about liberty. It's about limiting the federal government to certain enumerated powers and keeping everything else close to home. So while California may want weed legalized, then maybe Oklahoma does not. And each place can determine their own policies. Now, going further on that Rage case, I think it's really important to look at. At the time that ruling came down from the Supreme Court, there were 10 states that had active medical marijuana plans or programs or laws at the time that ruling came down. And since that time, not a single one was repealed. And in fact, 5 more states, most recently Arizona, the state's rights hotbed, also passed a medical marijuana law. So what does that tell you? Even though the federal government says marijuana is illegal in every situation, to grow, to possess, to sell, to consume, the Supreme Court has said that all state marijuana laws are illegal. 15 states are defying all of that and saying, we don't care, we've determined a different way to act, no matter what the federal government says. Now, we need to apply that same blueprint to health care, to our gun rights, to just about everything else. And we'll have a lot freer place in this country.
Well, I'm in Texas, and I highly doubt that we'll see medical marijuana laws anytime soon. But you say that's okay. Different states can have a myriad of different laws. You don't think that would be chaotic?
Well, that's the whole point. It's chaotic to not have different laws. And if you think of it this way, the founders wanted to create a system, and I think they were right in their concept, that if you have a huge country, and if you realize that even at the time The United States was huge at the time of the founding based on just the way the technology was. But we're a massive country. And right now we engage in a low-grade civil war every 4 years with one side or the other trying to control the entire landmass with their policies. Well, that's created chaos. Everyone's at each other's throats politically, when instead everyone can have their own way. We could have different viewpoints politically, religiously, economically, socially, all living together under one big defense umbrella in peace. If we allowed California to do one thing and South Dakota to do another and Wisconsin to do another and Georgia to do another, and that way people can learn from example. Well, maybe California's laws are awful, and then New Mexico or Texas says, oh, wow, look how poorly that worked there. We're not going to try it here. And this is how it's supposed to work. They call it the laboratories of democracy, even though democracy is a whole other story. But it's 50 different laboratories to test out different policies.
Right, so you can, in a sense, vote with your feet wherever you want to go. I fear that when you become the President of the United States, you're almost the President of the whole world with sort of this globalization that we're going to in terms of edicts and pacts and treaties and global law.
Sure, and the more power that there is in fewer hands, the more likely that power is to be abused. And whether you're from the left, the right, the center, or nowhere, you can't want one person to make all the decisions. We don't want a decider. So many people didn't want a decider when George Bush was in office. It's unfortunate that those same people have no problem with the new decider following many of the Bush policies and worse.
So I know that one of the big draws to the nullification movement has been Obamacare. Which states are challenging the federal government on this health care legislation?
Well, a number of states have already passed what I had mentioned previously, a Health Care Freedom Act. There's 7 states that have passed it. This addresses solely the mandates in Obamacare. It was Idaho, Utah, Arizona, Oklahoma, Missouri, Louisiana, and Virginia. They've basically said that the mandates are just not valid in their state, and they're primarily going through the courts to validate that, and that was the recent court victory in Virginia. Again, we really don't want to have to leave the fate of our liberty in the hands of 9 black-robed deities on the Supreme Court. So I don't have a lot of hopes that that's going to do something really well, and I feel that we really need to focus on a state level. Now, your state in Texas, there's a bill introduced called HB 297, the Federal Health Care Nullification Act, and this is really taking it to the proper constitutional step. It's not just saying mandates are unconstitutional. It's saying what it's supposed to. The federal government, under its delegated powers, has no authority to be involved in the healthcare business at all. And HB 297, the Healthcare Nullification Act, says the Obamacare plan, top to bottom, if passed, would be null and void in the state of Texas. And I hope people there will get behind it. We expect to see a number of other states around the country introducing a similar bill. So hopefully this will be a new path where states are simply saying no to the complete idea of federal health care plans.
Right. That was one of my questions, if people are nullifying the bits and pieces or the whole thing. I know in Texas we're going to have sort of an unfunded mandate if the health care legislation stays as is with all of our illegal immigrants in the state. Well, we'll come back to the Obamacare as well as other nullification initiatives going all around the country on every single side, left, right, and center, when we come back with Michael Boldin and guest host Zoe Russell.